Mr. Deputy Chairman, this is only an amending bill and the time is also very short. So I cannot take up all the industries separately, but I shall confine myself a few observations. Last year also in this house by about this time we discussed another tariff amendment bill. In connection with that, I made certain observations as well as suggestions for the government, but I do not find that any attention has been paid to these suggestions. My suggestions were to this effect that when any bill for granting protection or discontinuing protection to an industry was brought, we should be supplied with certain information under three categories. The first information was whether the protection granted to an industry had been used only by the indigenous industry or advantage of the protection had been taken by foreign capital entrenched in that industry, because sir, I submit that the main purpose of granting protection of certain industries is to develop our national industries. But if it is found that taking advantage of the protection, foreign capital goes into those fields where the industry is not highly developed or it does not involve a huge outlay or of capital or huge outlay of machinery, the protection becomes a farce. My second category of suggestions was that when protection was granted to an industry, it should be seen how far that industry was progressing properly and also how far it was taking steps to lighten the burden on the consumers. Thirdly, when we are granting protection to certain industries, we have the right to demand of that industry that it should give a fair deal to its own labor. I suggest that when notes are circulated to us in connection with a tariff amending bill, we should be supplied that information on these various counts, particularly these three. Lastly, I would like to make another point in connection with the soda ash industry. The question of this industry was discussed thoroughly on the floor of the House last year. The fact is that I gave certain suggestions and also drew the attention of the House to certain peculiar features connected with this industry. The domestic production is still far less than the actual domestic demand. That is why import of soda ash is being allowed. But it was complained that licenses for importing soda ash were given to the Imperial Chemical Industries. Secondly, Imperial Chemical Industries is a world monopoly and serious allegations were made against that concern not only by us but also by those Indian gentlemen who are engaged in the soda ash industry, that concern, taking advantage of its monopolistic position, was maneuvering the price of that commodity in such a manner as to put the Indian indigenous industry in very serious difficulties. The only ground or criterion on which the license was given to Imperial Chemical Industries for importing soda ash was that for a number of years it was the greatest importer. But if while granting protection to a national industry, we look at things in such a mechanical and superficial way, it defeats the very purpose for which Parliament is enacting this piece of legislation. About these things I have no information as to what is the present position, whether these suggestions were considered, whether the matter was looked into, whether any investigation was undertaken, and if so, with what result. On these matters we have not been supplied with any information. Therefore, I agree to some extent with my honorable friend Mr. Kishan Chand that we are confronted with some tariff amending bills in installments. These bills are presented before us as necessity arises, but while they come to us, we do not have the total picture before us. Whatever information is given is of a very general nature and superficial, and it does not really help us to understand the real position as regards those points which I have made out. Mr. Deputy Chairman, as the time is short, I should like to confine myself to 2 or 3 observations. First and foremost, in addition to certain information being given to members who are interested in the subject, it is necessary when the Export Advisory Council meets twice a year that invitation should be given to such members to attend these meetings. The government itself will benefit by the members listening to the viewpoints, but by those people who are in the trade. I had made this observation with regard to education advisory boards and every other body that members of both house should be informed about the meetings of such bodies, and they should be allowed to attend them as spectators. They will not take part in the proceedings, but there could be nothing lost as far as both the government and the members are concerned by the members being allowed to attend their meetings. Secondly, though this may not be exactly the occasion to deal with it, I want to put to the Honorable Minister this point and seek his advice. While moving the motion, the Honorable Member made a very fine speech giving us a clear picture of what the universities are today and what the universities should be. But sir, I was unable to follow the objects of the bill. The aims of the bill do not seem to be clear even to the farmers of the bill. In the statement of objects and reasons, it is said, the Constitution of India vests Parliament with exclusive authority in regard to coordination and determination of standards in institutions for higher education or research or scientific and technical institutions. It is obvious that neither coordination or determination of standards is possible unless the central government has some voice in the determination of standards of teaching and examination in universities both old and new. If we observe this statement, we can see that it is the intention of the farmers of this bill to have control over the universities, at least with regard to coordination of standards of examination. If that is the object with which this motion is brought, then I wish to submit that they should have introduced a bill for controlling the universities. If we go through this bill, my suspicion that the objects are not very clear to the farmers of the bill is confirmed, because on the face of it the title of the bill is University Grants Commission Bill. So the object that is intended is that a commission should be established and the commission should have control with regard to the utilization of the funds that are given to the universities. It means that the University Grants Commission should control the universities in respect of spending the grants that are made to the universities. But if you look at the provisions of the bill, they go far beyond this. Several clauses are provided here not only for universities which receive grants, but for all universities which have been asked to furnish particulars to the commission and to observe certain other conditions. Then they will also be made liable to certain penalties in case they fail to submit returns. I could have understood if these clauses were made applicable only to universities which receive grants, but it is not so. As per definition, university means a university established or incorporated by or under a central act or a state act under the concurrent list. So, I wish to know from the honorable members what exactly is the object of this bill, to have some sort of control over universities, to regulate the universities. Then I am afraid this bill will not do. He must bring forward another bill called the Universities Bill, in which they can have any provision to assume control over universities to any extent. On the other hand, if the object of this bill is only to exercise control over the spending of the grants made to the universities, if this is to be made applicable only to such universities as are applicable to the Grant Commission, then I am afraid of some of the provisions have to be deleted entirely or materially altered. This point I wish is to be made clear. Coming to the composition of the commission, it has already been observed by some of the honorable members that the number is either small or large. One lady member said that the number is small, while another honorable gentleman said that the number is large. The university grants commission provides for a small number, that is 5, and it should be so in order to make this commission effective.